welcome to Rightly Decided, the mostly original originalist takes of the litigators, or today, the lawyers, of the Texas Public Policy Foundation. I'm Laura Beth Latimer, and I am here with Chance Weldon, our Director of Litigation, and Andrew Brown, our Vice President of Policy for the Foundation. Andrew, will you tell us a little bit about yourself and why you're here today?
Sure. I've been with the foundation since 2018. My job today is Vice President of Policy, which basically means I herd the nerds. I oversee all of our amazing experts at the foundation, help them take their brilliant ideas and turn that into legislation that helps us fulfill our mission of making Texas and America the freest places on earth. Prior to that, though, I came to the foundation specializing in family law and child welfare issues. So anything related to foster care and CPS, that is my area of expertise.
And we asked you to be here today because something interesting happened last week. So we're here to talk about Mirabelli v. Bonta,
Yes.
which was a case off of the emergency docket for the Supreme Court. Dealing with the question of whether schools can refuse to tell parents that their children are transitioning in school. And this is an issue that's pretty close to your heart, right?
Absolutely. A few years ago, I was involved with the Senate Bill 14 fight, which, if folks will remember, that was Texas passed a bill that was ultimately upheld as constitutional that prevents the medical transitioning of kids who are struggling with a mental health disorder called gender dysphoria. Texas was a leader in the nation at recognizing that this is a harmful practice. Kids are struggling with legitimate mental health disorders, and then you have radical doctors and activists who are saying, well, you need to transition your child to the opposite sex, otherwise they're going to kill themselves. And so the way that we approached it in Texas was not to go after the parents, because in a lot of these cases, the parents themselves were being misled. They were being emotionally manipulated into consenting to these harmful procedures, but really to go after the doctors who were pushing this under the guise of science. It was, in fact, not scientific at all. And what we're seeing today is, across the world, a mass pullback from this radical experimentation that was going on for years on kids who really were struggling with a legitimate mental health disorder.
So this is sort of tangentially related to that. We're here talking about Mirabelli v. Bonta, which is a similar kind of related issue of the interaction of professionals and parents in children's mental health decisions, especially as regarding gender transitioning and those things. What do you know about the California law that's at issue here? Can you tell me about it?
Yeah, well, it's going to be no surprise to any of our listeners that California is being crazy, as Californians want to do. They had passed a law that basically allowed teachers and commanded teachers to keep a child's social transition at school completely secret from their parents unless the child consented to the school sharing that information with their parents. So essentially, a child struggling with gender dysphoria would go to school, change into clothes of the opposite sex, go by a different name, go by different pronouns at school. And if the kid said, "Don't tell my parents," the school was prohibited from telling the children's parents. And what happened was there were a group of parents who found out that this was going on with their kids and that they were being kept in the dark intentionally by the school. And they filed a lawsuit on the constitutionality of that policy, violating both their First Amendment rights as religious parents. There were a couple of parents were religious and had religious objections, as well as their fundamental parental rights. And that went all the way up to the Supreme Court on the emergency docket. And essentially, the Supreme Court said, no, this is likely unconstitutional. And California is currently temporarily prohibited from enforcing this law until the case can go up on the merits.
So there's one little thing that I want to unpack that you said. You said this came up on the emergency docket. I think there's a lot of conversation right now in the legal sphere about whether we call this the shadow docket or the emergency docket or the interim docket. This is just where things go that are not on the regular merits docket. So we're not talking about the case as a whole. We're talking about just this one very specific injunctive stay. Chance, will you explain for us what specific factors the court is looking at this point in just purely from a procedural standpoint? What factors is the court looking at this juncture on the emergency docket?
Yeah, really, to understand what they call the emergency docket or the shadow docket, it's sort of the litigation before the litigation. It's trying to decide what the status quo will be, what the rights and obligations of the parties will be while the case is litigated. And anyone who's been involved in litigation knows sometimes that can take years and years to litigate a case. And so it's very important to understand like what's going to be the status quo, what's going on while this case winds its way through the courts. And so for years, the way this would go up, you go up district court, court of appeals, runs up to the Supreme Court, and the Supreme Court will decide, sort of balancing the equities, balancing the harms, what the status quo will be. Now, the court's going to look at 4 factors, as courts often do with multi-factor tests. And they're going to say, what's the likelihood of success on the merits? They're going to say, what is the likelihood or risk of irreparable harm to both sides? And then the balance of the equities. This is public interest. What are the balance of the equities between the parties to ultimately decide what the status quo is going forward? And this is usually decided on a quick turnaround, sometimes without full merits briefing, without full merits argument, just to make sure that the status quo is set while the case goes forward.
And this one's kind of in a weird posture, too, because in this case, we actually already have a merits decision. The district court in this case had already made a full merits decision and issued an injunction, which then the Ninth Circuit stayed. And rather than waiting for the Ninth Circuit to hear out its process, the parents and the teachers went directly to the Supreme Court and asked the Supreme Court to stay the Ninth Circuit's stay of the injunction that they had already won at the district court. So it's a little bit convoluted, but the fact of the matter is the question that is actually in front of the court at this point is it likely, not a final determination, but is it likely that prohibiting teachers from telling parents that their children are transitioning is an unconstitutional measure? That's the only question that's really in front of the court at this point. And then they issue a pretty short little per curiam about whether or not this is unconstitutional. And Chance, will you explain just very briefly what the court held on this?
Yeah, it's really straightforward. As we said, there were 2 constitutional arguments in the case. The religious parents argued that they had a religious right to practice their religious faith, to be able to have some knowledge about what was going on with the mental health care of their children. And then the other parents had argued that they also had an independent parental right under the 14th Amendment, a right to direct the care and upbringing of their children that allowed them to have knowledge and participate in the mental health care of their kids. And the court held that under both of those rights, both the First Amendment religious liberty right and this underlying unenumerated parental right, that prohibiting parents from knowing what's going on with their children is in fact likely a violation of those rights. And in the interim, while that's going on, that would be an irreparable harm to the parents to make them not have a say in their child's upbringing for this 6 months, year, 2 years that this takes to litigate.
And I think we'll circle back to that irreparable harm issue, but there's a concurrence in this case, which we'll talk about a little bit more, and then there's a dissent in this case. What's the dissent mad about? Every time a dissent's issued, somebody's mad about something. So what is the dissent mad about in this case?
It seems like there's 2 things that the dissent is mad about, and it's a really interesting dissent that Justice Kagan wrote. She first goes after the process of the emergency docket itself and the fact that there actually was an opinion issued in this case, which is kind of hilarious because it seems like we're going back and forth as to whether or not we want opinions on the emergency docket or we don't want opinions on the emergency docket. And it fuels into that controversy that, you litigators, I'm a fake lawyer. You guys know better than I do. And then the other part of that is an examination of the parental right that derives from the 14th Amendment substantive due process. And Justice Kagan raises a really interesting and I would say legitimate critique of the conservative justices, wherein she says, you can't have your cake and eat it too. Conservative justices often rail against substantive due process finding unenumerated rights in the Constitution, but you're supporting an unenumerated right when you like that right. And I think that gives us a really interesting conversation to have about the status of parental rights, something that I think most people would take for granted. That, of course, my right to raise my child is a fundamental right that I have, and the state has to clear a very high bar before they can infringe on that liberty or restrict the liberty that I have to raise my child. That being said, it does derive from substantive due process. So for those of us who are originalists, textualists, the more conservative of us, we do have to really think deeply about the nature of parental rights as a constitutional right.
And where we derive them from. I think Kagan says in the dissent, substantive due process has not been of late in the good graces of this court, which is exactly where Justice Barrett jumps in and says, oh, nay, we haven't said that substantive due process isn't important. We haven't said that it's not a thing. We've just said that it needs to be narrowly tailored. Chance, what do you think about Justice Barrett's perspective on that?
Well, I think you have to first unpack what substantive due process is for the listeners. So the 14th Amendment, when it's adopted, it does two things. One, it prohibits the states from denying life, liberty, or property without due process of law. And it also guarantees the privileges or immunities of citizens. States can't deny the privileges or immunities. That's the Privileges or Immunities Clause and the Due Process Clause. Now, there are two ways to go about protecting rights. One would be to say that parental rights are part of these privileges or immunities of citizens that are protected. And that's a term of art that folks like Justice Thomas and others have said include the right to direct the care and upbringing of your children. Mm-hmm. But just through a quirk of history that would take way too long to go through, those rights end up being incorporated through the liberty provision of the Due Process of Law Clause of the 14th Amendment. And through cases like Pierce and
Pierce v. Society of Sisters
and Meyer versus Nebraska, the court has said that the liberty protected by the Due Process Clause includes this right to direct the care and upbringing of your children. So the question is, what liberties were protected in 1868?
Why is that the question?
Because you're looking at, if you're looking at a restriction on the states, if you're a textualist or an originalist, and you're vesting that somewhere in the Constitution, and you're vesting it in the Due Process of Law Clause, what you're looking at is it protects life, liberty, and property, except by the due process of law. And so you're looking at, is this one of those liberties that would be protected? And what the court has said since at least, the early 20th century is that includes the right to direct the care and upbringing of your children. Now, that's vested. We can nerd out like way deeper in American history. But the question for originalists over the years has been like, well, what are these liberties? Like, do judges get to make them up? And the argument has historically been that, no, you look at what the understanding of that term would have been in 1868 when the 14th Amendment was ratified. And is this in the basket of rights, either under the Privileges or Immunities Clause or under the general understanding of liberty in 1868? And so it's not a grab bag of whatever liberty might be in vogue. It's liberty as it would have been understood, or privileges or immunities as it would have been understood in 1868.
And this might be kind of a simplistic point to make, but I think it's really important to circle back to why this particular date, why do we care what they meant then? And it's that when we're doing interpretation, our question isn't what should the Constitution say? Our question is, what does the Constitution say?
Yeah.
And in order to know what the Constitution does say, we have to know what the language would have meant at the time. There's that, I think last week Nathan Seltzer referenced it as the if your grandmother tells you don't get fresh with me, we need to know what she meant by that. What to get fresh with meant 20 years ago when she started adopting that term. We have to understand that in order to understand that what she's saying is, if you keep talking like that, I'm gonna bop you upside the head, and not, don't wear deodorant on a Sunday, something like that. So this is important linguistically for us to understand not just what the Constitution says, not just what we want it to say, but what it actually says and what it actually means. Which is the core of originalism.
Yeah, and that's because the Constitution gets its moral legitimacy from the fact that it's a contract. At least we operate under that assumption that it's a contract. And so the same way that we would interpret a really old contract where everyone's dead, right? We're going to interpret the Constitution the same way because its binding force comes from the fact that it was consented to. And if you interpret it in a way that departs from its original public meaning, then you're moving outside that original consent. Mm-hmm. So all of the moral legitimacy of the Constitution as a contract comes from reading it the same way we would a contract, which means we're looking for that original public meaning. And so we're trying to understand what liberty would have meant according in this case to the ratifiers of the 14th Amendment.
So I think Justice Barrett takes a slightly different approach to it in her concurrence here. She says, substantive due process asks us to find unexpressed rights in a constitutional provision that guarantees only, quote unquote, process before a person is deprived of life, liberty, or property. And then she goes on to talk about Glucksberg and, how we actually find these rights within that guarantee only of process. Is she right? Is that the only way of looking at the due process clause, to say that this actually only guarantees a process?
Well, I mean, that's been a fight amongst originalists for a long time. And one of the things that's important to remember is, again, you're looking at a term of art in law. So, and the question there is not just due process. It's not just the due process clause. It's the due process of law clause. And this language, this sort of basket of words, goes back to Magna Carta. And it goes back to state law of the land clauses like we have in Texas, right? And what that term typically meant, law wasn't just whatever the legislature passed. There's a broad body of scholarship that says that law had inherent limitations. We talked about this last week with Calder versus Bull, right? That even states had to pass something within the police power, right? So there's some inherent limitation under the due process clause, that it can't just be anything that the legislature passes. But there is this sort of discomfort with something that's based on process, also involving these substantive limitations on the legislative power, which is why some justices like Justice Thomas have previously argued that the substantive limitation on the legislative power is more comfortable in the Privileges or Immunities Clause. But that's probably a little far afield from what you're asking.
No, I think that's exactly what I'm asking. And this is just a general question for you two. Why do judges and justices treat substantive due process like it's a dirty word? Why do we treat this like it's the bastard stepchild of liberty in our system?
I think it's the slippery slope of it recognizes that there could be this entire universe of rights that exist that we don't even know about, that we may discover one day, right? I think the easiest example of that in recent memory is the right to abortion. And this was a big issue in Dobbs overturning Roe versus Wade. Again, getting back to Glucksberg, this idea that for an unenumerated right to be considered fundamental, it has to be something that is deeply rooted in the history and traditions of our nation and implicit in the concept of ordered liberty. The court in Dobbs basically said abortion is not that. It does not meet that high bar. That's the big difference to me with parental rights. Parental rights, I think, not only meets that high bar, it clears it by a mile. And I would even argue that parental rights are something that are on the strongest ground when you're talking about an unenumerated right, because they pre-exist the state, right? You don't have the concept of government. You don't have the concept of a state unless you have families. Families are formed. They get together, they form a society. That society eventually gets big enough to where it needs to have some type of structure to keep order. And then the government is formed out of that, right? John Locke calls the parental relationship with their child a form of natural government, right? It's something that does not need the permission of the state to exist or to be maintained, right? And so this is something that's not just deeply rooted in the history and traditions of the nation, it's deeply rooted in the existence of humanity itself.
And I think the question there, though, would be, did the people who ratified the 14th Amendment, would they have been familiar with this history? Would they have been familiar with this tradition?
Absolutely.
Would this have been something that court cases already before the 14th Amendment were ratified had vested that right in, say, for example, state law of the land clauses or state due process clauses? Do we see that in the history, that in legal treatises that were written at the time, that parental rights were recognized?
Oh, yeah, you absolutely do. And I'm drawing a blank right now. I'm trying to go back to law school. But this is something that I think is very clearly a concept, an idea that not only would have just been recognized by the framers because of their knowledge, their scholarship, but honestly would have been taken for granted by them, right? The reason why it's not enumerated is because it's logical, right? We don't have to enumerate this. Of course it exists. Everybody believes that this exists. We've ordered our entire society around the existence of the family. And so that's, to me, one of the really interesting things about parental rights is we're now in a place where we're having to come back and we're having to say, oh no, this exists, and we're Texas, we're passing constitutional amendments just within the last year that actually put it in the Constitution because our society has, in my opinion, degraded so much that we now have forces out there who are saying, no, the state is the ultimate decision maker about what happens to someone's child. And you have to have the permission of the state to be a parent, right? And this may sound crazy, but there are law professors out there. One guy named James Dwyer, he's a professor at William and Mary Law. He argues that every parent should be required to demonstrate the ability to adequately care for their child before having their rights as a parent recognized by the state. And I'm going to give you a direct quote from Dwyer to show you the threat that we're facing. He says, "Children must not begin life legally tethered to or in the custody of dysfunctional people living in horrible neighborhoods." So there are very smart, ostensibly people out there who are saying, in order for you to have a child and to be a parent to that child, you need to get the permission of the state first.
So I think there's kind of an elephant in the room that's undergirding all of this, and that is the issue of child abuse. So in my history and background, I was a prosecutor for 4 years before I came to the foundation, and I was a child sex crimes prosecutor. So child abuse is something that is near and dear to my heart, and of course that means that we see in the shadow of this parental rights discussion is the argument and the concern that not all parents are good parents. Child abuse is very much something that actually occurs. How does that dynamic play into this particular discussion?
Right. And I'm going back to Locke. I love going back to Locke on this issue because, he really does articulate the nature of this natural right better than anyone, I think, who's ever written on it. Locke says that the rights of parents derive from their responsibilities that they owe to their kids, which is to protect, nurture, to train for adulthood and to be a member of society. Those two things are inseparable from each other, right? Your rights as a parent exist to the extent that you fulfill your responsibilities to your children. No one has the right to abuse their child. No one has the right to harm their child, right? So if you as a parent violate your responsibilities to the extent that you cause harm to your child, then there is a legitimate role for the state to play and to restrict that liberty, to restrict those parental rights.
And I think it's important to unpack why that matters as a matter of legal interpretation, because a lot of that sounds like we're talking about policy or what our philosophical beliefs are. Right. But what you have to understand is the folks who wrote the 14th Amendment, they were largely Lockean. They had read a lot of just like the founders, they had read a lot of John Locke. They cited it in court opinions at the time. And you have cases from the 1840s and 50s recognizing that parental rights were part of this basket of rights that were protected under state due process clauses before the 14th Amendment was ratified. And so that understanding would have been incorporated into the 14th Amendment. And part of that understanding, like all rights at the time, were subject to the legal maxim, sicut non laetus. I can't say the whole thing because I never remember it.
We're going to Latin now. It's getting fun.
But the general understanding was that your rights don't include the right to harm others, right? So you can't cut off your kid's body parts, right? You have this duty to direct the care and upbringing of your child, and that includes some rights that are protected. But you had legal commentators, Chancellor Kent had written about parental rights going back to 1815. You had again, all of these other cases that were being decided before the 14th Amendment was ratified that recognized this Lockean natural right to direct the care and upbringing of your children. So you have this ability to incorporate that right into the 14th Amendment in a way that you didn't have the ability to incorporate, say, a right to an abortion. Right? There was no long-standing pedigree that was recognized in 1868 as a fundamental right, because it does involve, in fact, harming another individual in a way that directing the care and upbringing of your children does not. And so when we talk about, why abuse is not protected, it's not because abuse is bad and we don't like abuse. It's because when you're looking at the text of the Constitution, whether that be liberty under the Due Process Clause or privileges or immunities, The right to direct the care and upbringing of your children has just never included the right to harm them, just like the freedom of speech doesn't include the right to punch someone in the face, right? Even if you do it because you have a deeply felt religious belief, like your right to religion doesn't include the right to do human sacrifice. It's because this maxim in law has always been sicut, and that also applies to parental rights as well. And so we're not doing policy here. We're just saying, what is the scope of this right as it would have been understood in 1868?
And while we're on that topic, I want to get back to the opinion itself. I think overall, a very strong opinion for parental rights. The court correctly applied the precedent that it's, quote, parents, not the state, who have the primary authority with respect to the upbringing and education of children. They correctly identified that strict scrutiny applies anytime the state is seeking to insert itself in that private realm of the family. There was one sentence in the opinion that when I read it, all kinds of alarms
I was
went off
going to
in my
ask
brain.
you about that next, because
Yes.
it's a weird one. It's a weird little exception.
And so there was this, what the court was trying to do was provide a hypothetical. And they were trying to make a point about California's policy was not narrowly tailored enough, right, in order to clear that strict scrutiny hurdle. And so the court gave a hypothetical of a policy that could be narrowly tailored enough. And that hypothetical was, and I'm quoting from the opinion here, the state's interest in safety could be served by a policy that allows religious exemptions while precluding gender identity disclosure to parents who would engage in abuse. And it was that would engage in abuse that made me go absolutely insane in my office. Because essentially what you've done is you've created a loophole with this one phrase. It is a hypothetical future thing that may or may not occur. It is basically leaving it up to the judgment of the school administrators to say this parent might abuse their child at some point in the future if we disclose that their child is socially transitioning at school to the parent.
It also doesn't define abuse.
It doesn't define abuse at all, which is critical as well, because when you look at states like California, Oregon, Washington, some of the more really strong lefty states, they are actively defining non-affirmation of a child's gender identity or sexual orientation as abuse. There are multiple cases of children being removed from their families solely because the family does not affirm the child's gender identity or sexual orientation. And so what this one clause, this one phrase in the court's hypothetical does is it enables the school administrators to say, well, non-affirmation is abuse, so clearly these parents who are not supportive of their child's transitioning are abusive, and we can keep all of this a secret from them.
You're not suggesting that government lawyers might try and circumvent an order from the Supreme Court,
I
are
would
you?
never do such a thing, Chance. When has that ever happened before?
No one would ever do that. I do want to push back on that just a little bit, though. So this is... Obviously, this has come up on the emergency docket. We've talked about that a few times, which means that there wasn't full merits briefing. And this particular issue isn't really what's in front. This is dicta, right? This hypothetical is dicta.
Which is the thing that gives me a little bit of, okay.
But also, I think that there's probably a way to phrase that hypothetical such that it would actually be legitimately a good expression of narrow tailoring, right? If they were to say, except by proof, whether it's beyond reasonable doubt or clear and convincing evidence, before a neutral arbiter, that this parent would engage in some sort of abuse. Now, the problem with that, of course, is that that's going to require notice. And if you're giving notice to the parent, hey, we need to go take this issue in front of a judge so that you don't abuse your child. Now you've put that child in a difficult situation. But really, the issue with that hypothetical is a procedural one, right? This is a question of what needs to be shown. First of all, what is abuse? The definition of abuse needs to be established by the court before we just say anything that the state decides is abuse is abuse.
Right.
But also, we have to deal with the procedure of how do we know that these parents, quote unquote, would engage in abuse? What standard is required?
Right. And that's the hard part when it comes down to abuse and neglect, and when the state can take this very dramatic action of coming into your home and forcibly removing your children from you, potentially forever. Right. This is a nuclear bomb that the state has the ability to drop on a family. The way that we approach it from a policy standpoint is abuse involves harm or the imminent or immediate danger of harm. And by that, we mean something that it's so clear that unless we intervene at this moment, something bad is going to happen to this child. So it's either something bad's already happened that we know about. Those are the easy cases. Or if we don't do something now, the clock is ticking and something horrible is going to happen to this child without intervention, right? But again, that comes down to what does the state throw into this big hodgepodge of abuse and neglect, right? Abuse is a little bit easier to define because there's generally some type of physical manifestation. Neglect's harder because neglect really kind of starts going down into this, well, I know it if I see it category.
Well, and there's always that danger too. Exactly that quote that you read of, are we just talking about I live in a bad neighborhood? Is that a good enough reason to say that this child is being neglected? If he's in a loving home, but it's an impoverished situation, is that neglect?
I would say no.
But
Absolutely
we've seen that over the years.
A
lot of times the bureaucrats will treat poverty as if it's abuse.
It's
right?
often conflated.
Yeah.
Right. Now, the extent to which that happens is an ongoing debate amongst folks who work in the child welfare world is, are we really confusing conditions of poverty for neglect? How much does that happen? I think it happens a lot more frequently than people realize. But, even cases like you've got a single mom who's raising kids and, her babysitter's late coming over. She's got to catch the bus or she's going to lose the job and leaves her kids for a few minutes by themselves in the apartment. And they're probably too young for her to be doing that, right? Is that neglect? Or is that a product of she's a good mom doing the best that she can in a really bad situation?
Yeah. Kind of coming back to that legal issue of standards, right? Of, is this something that we have to prove beyond a reasonable doubt? Is it something we have to prove? So the state of Texas did something kind of unusual maybe last year. Unprecedented. And passed a constitutional amendment affirming that the right to, well, what's the language? I know you have it memorized off the top of your head, or at least I think you do.
I don't have it memorized. I had to go back and write it down. So the amendment, which was enacted last November, it was Proposition 15 on the ballot during the November 25 election. And the amendment affirms that parents have the fundamental right to exercise care, custody, and control of the parent's child, including the right to make decisions concerning the child's upbringing, as well as the responsibility to nurture and protect the parent's child. Essentially, what we did with the legislature in drafting the language of this amendment was Texas went back to that 100+ years of both United States Supreme Court and Texas Supreme Court jurisprudence on parental rights and distilled a century's worth of holdings into a couple sentences. And it's fundamentally a Lockean framework when you break it down of that balance between the rights and the responsibilities and how those two things interact with each other. But ultimately, what this constitutional amendment means is that it is ultimately the parents who are the decision makers for their children, and the state has to clear an incredibly high bar before it intervenes and restricts the rights of parents to direct the care, education, and upbringing of their children.
So, go ahead, James.
I was going to say, and to tie it back into the opinion that we have today, it was important to enumerate that right, because for some folks, they argue if a right's not enumerated, then it simply doesn't exist.
Correct.
And so, and to tie it back into the opinion today, I mean, it's not very often you'll get a shout out for Elena Kagan on an Originalist podcast, but she does have a point in her dissent here for calling out the conservatives, because there are some, Justice Scalia was one of them, who had argued that if a right's not enumerated, then it simply doesn't exist. Right. And these great parental rights precedents that we have that are over 100 years old now, if you look at Pierce versus Society of Sisters, if you look at Meyer versus Nebraska, what do they cite as authority? Lochner v. New York.
Right.
And there are a whole host of...
I knew you were going to get back to Lochner. I was waiting
Lochner,
for it.
Right?
It's a great case.
But there are some conservatives like Scalia and like Justice Roberts and like Justice Kavanaugh that have historically dunked on Lochner. And one of the tensions has been for years is you can't have both. Mm-hmm. You can either dunk on Lochner and say that substantive due process is not a thing and unenumerated rights aren't a thing, or you can have Pierce versus Society of Sisters and parental rights. But you can't have both. Mm-hmm. And I think what, and conservatives have for a long time in the originalist camps have sort of refused to deal with this. Now, in fairness to Justice Scalia, he bit the bullet and he just said there are no parental rights that are protected. That was his opinion in Troxel, right?
Right.
But so what this constitutional amendment does in Texas is it resolves that tension. Mm-hmm. Now, we've thought and we've argued in our SB 14 brief, right, 2 years ago now, that this unenumerated right was protected in 1876 when the Texas Constitution was ratified. But to eliminate any doubt, it is now enumerated in the Constitution, so originalists of all stripes can recognize it.
And Texas is the first state that has taken this step of enumerating parental rights in their Constitution. I'm hopeful that more states will follow suit now that we've taken that leadership role as a state. I don't want to have the visitors. I'm the visitor. I'm the guest today. I don't want to have our viewers and listeners leave with this fear that all of a sudden, parental rights are going to just vanish out of existence one day. I don't think that is a threat that's near at hand. I can see a world in which that is steadily eroded over time.
Yeah.
Right.
Yeah.
But enumerating these rights in the Texas Constitution and hopefully in other state constitutions really prevents that erosion from happening. And part of the political calculus that the legislature was making is we had been on a streak of some really, really good parental rights decisions from the Supreme Court of Texas. We've got a great court on parental rights in Texas. I think we've got a great court at the U.S. Supreme Court for the most part on parental rights. Let's seize this political moment right now. Let's establish a really strong beachhead. That way, if the court flips in the future, we've already put the fortifications in place to where the parental rights protections won't be eroded.
And Texas will remain safe.
And it's important to point out that in this opinion, it seems like all of the justices agreed that parental rights exist, at least at some level, right? And so we'll just see how that shakes out.
And I'm not calling for an uprising, but I think if you did get rid of parental rights, that's one of the quickest ways to a revolution in this country that you can get.
Yeah. Absolutely. Okay, so one last thing. We've got just a few minutes left. I did promise that we would come back to this irreparable harm issue. Chance, why does the discussion of irreparable harm in this case matter? And how does that affect us moving forward, us being the Texas Public Policy Foundation?
Yeah, I mean, we litigate a lot of these cases where people's rights are being violated. And we litigate cases against government overreach where we represent plaintiffs who have to run up through the courts. And one of the things that happens is if you lose at that initial stage where you're seeking a preliminary injunction, or if you have something that's affecting your rights, you want relief quickly. You don't want to wait 5, 6, 7, in some cases, 8 years to get final adjudication. And so the status quo really matters. And there's been a fight. There are competing precedents from the Supreme Court that whenever you're doing this balance of equities, there's one line of cases that says when you enjoin a government action, that's irreparable harm to the government because they don't get to enforce their policies. And therefore, it sort of collapses into the merits. And then there's another line of cases, which I think is right, which says that whenever you deny a right, a fundamental right, even for a short period of time, that denial itself is irreparable harm because in most civil rights cases, you can't get damages after the fact that will fix that. And if you're talking about parental rights, right. Like some of the most fundamental rights, we're talking about the mental health and well-being of your child.
Right.
I mean, that could be a real problem if you have to wait 6 years before you address this issue, if you're kept in the dark.
If your kid was 12 when this started, they might be 18 by the time you get an answer.
Right. And so that itself is an irreparable harm. And so to have the court saying that the deprivation of a constitutional right is irreparable harm reinforces this line of cases that when you're doing that 4-factor test to get an injunction, you can now point to this and say, yes, the deprivation of a constitutional right, a parental right, even for a short period of time, is an irreparable injury. And so most of the analysis is going to be, are we likely to prevail on the merits? A lot of this will just collapse into the merits. And I think that matters.
Which is, I think, absolutely why the dissent gets so up in arms about this particular issue being handled in a per curiam on the emergency docket, because it does just kind of collapse into the merits of the issue. But that doesn't mean that this particular issue isn't so vital that we see irreparable harm to these families if this stay isn't granted.
And honestly, so much of this rhetoric around the shadow docket or the emergency docket really boils down to people get mad when they don't like the outcome, and people are, all of a sudden that anger disappears when they do like the outcome. Like no one seems to object when the shadow docket works out the way that they want it to. They tend to object when it doesn't. And so I get it, but at some point there has to be someone who decides the status quo while the case is litigated, and that's been there since there's been a Supreme Court.
So I think that brings us to the end of today's docket. If you enjoyed our conversation today, please leave us a review and join us next time for more Rightly Decided.